Afternoon, Your Honor. Howard Borg, representing Rural Housing Service. The creditor has filed an objection in this case. The case is up for confirmation. It was passed in the docket 2 months ago at the joint request of counsel to solve some problems in the case. We got to this point, some are solved, information has been exchanged. We're not at that point yet. I won't go into great detail, but Rural Housing Service holds the home mortgage on the debtor's residence. Other than a small car loan and some $11,000 in general unsecured, we're the only creditor, definitely the only major creditor. It comes down to 2 objections currently pending on the plan. One for the amount of the pre-petition arrearage owed that will be included in the plan and paid in the plan, and 2, objection to feasibility.
Because the mortgage goes up a little bit?
Yes. And that is, the counsel for the debtor has requested that we determine the amount to be included for post-petition arrearage at the TRCC stage rather than confirmation. It's been my experience in Fort Worth, we generally do that at the confirmation stage, and I have to concede this counsel is more experienced than me in the Dallas courts, and therefore I come on a relatively light day just asking the court for a little counseling, instruction, spoon feeding as to does this court want to litigate the amount of the pre-petition arrearage in Section D of the plan at confirmation or TRCC? And if the court says in TRCC, then I, to protect my client, want the luxury of having the court telling me that all my objections and my objection to confirmation are fully preserved with right to litigate those at the TRCC stage. We have some disagreement on the wording of the form plan that he says preserves that for me automatically. I question whether it does or not, and I don't know how much spoon feeding the court wants to do with giving advisory opinions on that. But the main issue before right now is my not disagreeing or being willing to agree to his passing the determination of the amount of the pre-petition arrearage to the TRCC stage if the court will preserve for me on the record that I'm not waiving anything and I have fully preserved that. Then I go to my second stage that, gosh, Judge, tell me what y'all want to do over here and how you want to do it, and can I talk about the wording a little bit?
Mr. Borg, first I'll react to when I was a lawyer and you represented the U.S. government, I don't feel like I got to spoon feed you too much. I think you got to whip me a lot of times, so I'm just not sure I'm in a capacity to spoon feed you this afternoon. What's your reaction to that? Can we preserve the government's rights so that if this isn't settled that we would then
Yes, Your Honor, I and I believe the trustee and most people interpret the language that's included, the bold underlying language in the standard plan that says that except for valuation interest rate, confirmation hereof shall be without prejudice to the debtor, the trustee, or any secured creditor to later determination of the allowed amount of any creditor's secured claim. It's pretty much standard practice in this district, in Dallas at least, that most of the time the mortgage arrears claims are not one-on-one accurate with what the actual claim gets filed. It's $1,000 difference, sometimes it's $20,000 difference.
I don't recall what the spread. I looked at your plan, also looked at Mr. Borg's objection. What's the spread right now? What's the difference?
They put in $30,000 in the plan, and we have, I believe, $51,000.
Yeah.
And I think that may have to do with the escrow shortage is where that's coming from.
Okay.
And then there's a reamortization agreement that was supposedly executed or should have been executed in 2005, and they can't find a signed copy. So if that is signed or not signed, also would affect that pre-petition arrearage.
Okay.
And so we have some problems with a claim that we would like to dig into deeper, which is one reason we asked for it to pass the TRCC.
Okay. Well, on this record, I would find that we can confirm and then preserve all of RHS's objections in the event that an agreement is not reached. All right?
Thank you, Your Honor.
Thank you, Your Honor.
Thank you. And you know I'm teasing you, Mr. Borg. I always enjoyed when we were against each other and go ahead and in my court now.
One reason I enjoy coming to Dallas is this court's sense of humor and not afraid to have a sense of humor. Thank you, Judge.